Proceed. Any seconder? Any seconder? What's wrong with your mic?
I so second Mr. Speaker.
I'm going with him. Give him the mobile mic. All those in favor say aye. Those against say nay. The ayes have it.
Record of votes and proceedings for Tuesday, 4th August 2026.
Proceed. Okay. Honorable members, the record of votes and proceedings. Pages 1 to 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. 13. 14. 14. 14. Yes, honorable. Which one? 14? Page 14, page 15, and 16. Can the member please move?
Sorry, Mr. Speaker.
Any seconder?
So second.
All those in favor say aye. Those against say nay. The ayes have it.
The record of votes and proceedings for Tuesday, 4th August 2026 has been adopted. Announcement by Mr. Speaker.
We proceed.
B. The Constitution of Sierra Leone Amendment Act 2025. Committee stage on third reading. The Attorney General and Minister of Justice. The House is open. The House is also the committee of the whole. Debate continues.
We are on page 13. Page 14.
Yes, Mr. Chairman, page
Speaker.
14.
Yes.
My name,
Oh,
Mr. Speaker.
yes. Yes. Proceed.
Chairman, honorable members, with your leave, I beg to take us back a little bit, just a little bit, Chairman and honorable members. Chairman, honorable members, you recall that during the last debate, we discussed the inclusion of the provisions in the Guinea Act into the Constitution. For that, we are grateful that honorable members of Parliament, honorable members of Parliament.
Hold on, that is on which page? 10 and 11. Page 10 and 11, not so?
Yes, Mr. Speaker.
Proceed.
And that was.
Oh, sorry, I don't think it's page 10.
Not 10 and 11.
We can go back, just deal with the amendments.
Section 35.
35.
Yes. So clause 3, section 35 of the Constitution. So,
Which page? Which page? Of the
Page 5.
Page 5. That's on page 5.
And then later page 7.
yes.
Yes, agent.
Mr. Speaker, honorable members, we did indicate that section 35 has to do with the conduct of political parties. And so we believed that any such addition should be included in the exercise of executive authority. Mr. Speaker, Mr. Chairman, other honorable members, the proposal ties in with a call that was made by His Excellency the President during his last state of the Republic, his last statement before this honorable House. He called on us to have a genuine dialogue about proportional representation, including in the context of executive authority. We note that that particular call generated significant debate across the country, whether that meant power sharing or something else. Noting that call and the debate that followed, and going by the proposal that was made by member of the opposition, Honorable Kamara, or that we extend similar commitment to the constitution of the executive arm of government. We now propose, Mr. Speaker, Mr. Chairman, honorable members, we propose an amendment to section 59 of the Constitution. Section 59 has to do with the establishment of cabinet. With your leave, I'll read some portions of it. There shall be a cabinet whose functions shall be to advise the president in the government of Sierra Leone, and which shall consist of the president, the vice president, such ministers as the president may from time to time appoint. And then, of course, there's section 2. The person appointed as minister, a member of cabinet, shall vacate his seat in the cabinet if he ceases to be a minister, president director. Mr. Speaker, we would propose a renumbering of this particular section, but with the inclusion of a new subsection to read that in appointing ministers under subsection 1, as of section 59, the president may give consideration. The President may give consideration as far as practicable. So, A,
Shall or
no, I said may, not shall. The President, in appointing ministers and deputy ministers under subsection 1, the President may give consideration as far as practicable to A, the political diversity of Parliament, B, the regional and district balance of the Republic, C, gender equity, in line with what will now be that section classified, subsection occupies under section classified, and then D, the inclusion of minority groups. We will propose the inclusion of this subsection under section 59. Mr. Chairman, honorable members, this is important because it is our firm belief that government across all sectors should reflect the diversity of our country, should be inclusive, and should be representative of the people. And we believe that in addition to the requirement that has been made of Parliament, I'm including this for the President's consideration in constituting his cabinet or cabinet will be a significant step towards achieving the goal of inclusion, participatory governance, and the diversity of our country. I still submit, Mr. Chairman, honorable members.
Let me hear the
Mr. Chairman, many things are not clear in what is proposing. And where there are mixed laws, there are certain ambiguities that must be made very clear. Two things. One, he quoted me, and what I pushed for was a shall mandatory clause on 30%. That if we have 30% in Parliament, I believe we have capable women in schedule that can address, that can fill in every given opportunity. So if he's quoting me, I wanted to be quoted right, and I said shall. The other thing he mentioned when it comes to the issue of appointment is in proportionate to the configuration of Parliament. You know, I have said it is good we come clear with our intentions and we try not to cover up and create a situation as if we on this side are not thinking. What we are doing here, when you speak, we listen, we think, we process at the same time. We are not begging for a power sharing situation. And if we say no to it before now, we still start to say no to it. If the discussion of regional balance, the president should do everything possible to have a regional balance in cabinet, correct? But if you tie that to proportional the configuration of Parliament, tell us clearly you want to propose IPI and the executive arm of government. If we accept as a people of Sierra Leone, we accept. If we don't, we will not accept. But trying to.
So what is debatable?
What is debatable is a position he has made that I first of all I want him to be clear with what he said, which is not clear. And so most people who are here do not understand what I am understanding.
Explain what you understand. So explain what you understand. The man understand. The man understand. You explain what you understand. Explain what you understand. Don't know explain. He said understand. But I have got everything. Yes, I move it. You are right, sir. We agreed on this issue. For me, I agree with him, but not on section 59. Earlier, I think, but section 59 is limited only to cabinet. That is one. So I'm suggesting a rephrase of the opening paragraph, but standing on section 61 instead of 59. Because section 69, section 61 covers both cabinets, ambassadors, commissioners, board members, director generals. It covers everything within the president's power. So it's like saying, in exercising his authority under section 61, the president may, we agree on that may, because even in the GUE Act, the clause there is may. In the GUE Act, we agreed. Although if I had known at that time, I would have disagreed. But unfortunately, it was too late for me. So it is made in the GUE Act. So that is why the exercise of presidential authority to appoint 30% of women, we still agree on May. But if the GUE Act is scoring more votes, even on that May, I think we can continue to score that. But we don't want to limit it. GUE Act limited it to only elective positions. We want to include now appointed positions. But section 59 limited appointed positions of cabinet only, while 61 covers all. So I'm suggesting that we refresh, but we stand on section 61 instead of 59. That will cover everybody, and that will be good for women.
Thank you very much. Honorable Geba.
Thank you, Mr. Speaker.
Okay, hold on briefly.
Mr. Chairman, honorable members, two issues. First to Honorable Abdulkarim Kamaran, just to make some clarification. My reading of this.
Hold on, Mr. Minister. I said Honorable Geba. Are you not debating anymore?
No, I'm debating.
Please hold on.
Why not you say hold on? Thank you, Mr.
Hold on, Mr. Minister.
Mr. Speaker, I am sure this idea is a welcome idea, even for those that we represent in this house, hearing the Attorney General for the very reasoning of it. Every Sierra Leonean will warm up to this idea that what was mentioned by the President during the last state opening of Parliament, that the proportional representation be extended to the executive arm of government, be something that we think of. And like my learned colleague has said, I will agree with him as well, but that it could still fit in section 59. That if you are introducing it in section 59, you can still spell out ambassadorial positions. Because section 59 is also dealing with the appointment of ministers or the power of the president in exercising his powers in appointing ministers and the like.
Mr. Chairman,
Yes.
If he is suggesting the inclusion of ambassadorial, what about board members? What about director generals? Yeah. What about the executive secretary? Section 61 covers all that in the opening paragraph.
It's all right.
That is one.
It's all right. I please give the minister 1 minute to just respond to that.
Yeah, thank you, Mr. Chairman, honorable members. And just to say, to clarify, in reading out this proposal, there was no use of proportional, apart from the president calling for a genuine dialogue. And so the reading of it in relation to Parliament, I did not say proportionate. I said in appointing ministers and deputy ministers, the president may give consideration as far as possible to the political diversity of parliament. I didn't say proportionate. Those are not answers. But just to say, Mr. Speaker, honorable members, we take note of the intervention made by the deputy leader of the opposition, and this is to note that we will agree in entirety that this provision that we seek to introduce in the Constitution be put under Section 61.
I totally agree. Not 59 or 61. I totally agree. No, don't debate that.
No, I am not debating that.
Don't debate that.
No, he has quoted me. No, that's the issue.
I'm quoting you.
No, it's not quoting me, Mr. Speaker. We are making the law.
It's all right.
And he's saying,
it's all right.
Let's not be all right.
Do you know why I'm stopping you? Because of relevance. We are not here for whether it's quoting you or not. We are dealing with the provision.
Thank you. And that is what I have a problem with.
No, your argument is not relevant to the proceeding.
No, it's not all relevant.
Because of whether it's quoting you or not.
I am. Mr. Speaker,
don't refer to quoting you.
No,
refer to the provision.
That's exactly what I'm
yes.
Mr. Speaker, the minister is very clear about presenting this issue. And he has come very clear that the president can appoint in line with a regional balance, which is correct. But if you tie that to the configuration of parliament, it signifies political parties in parliament and their strength. So we are saying for national balance, which is what we seek to address since the starting of this constitutional review. Let us limit the appointment of president to reflect regional balance, which is just an address of all other issues. Because even when you talk about political steering in parliament, the political parties are the configuration of the country. So if we say, for example, each region should have equal representation of cabinet, it surpasses political representations at parliamentary level. That's just my position.
It cannot be equal representation from the regions. Mr. Minister, what do you say? Before
Mr. Speaker, I don't see how this is. You use one not to the exclusion of the other. If you say, even without this provision, the president is free to set up a government or make appointments reflecting the regional balance in the country or the political diversity. We basically will just say it's an issue of pay, not an issue of shall. It's something that the Constitution will encourage the president to consider the political diversity of parliament. If the honourable member feels so strongly about it, we could change parliament to country. And then, the regional balance, gender equity, etc., etc.
Is there anything wrong with regional balance? Is there anything wrong with that? Are you okay with regional balance?
So it is there already. Under B, say regional and district balance of the republic. But
regional and district.
Yes, but the A part of it is the political diversity of parliament. That's
hold on. As long as regional and district balance.
And then of course,
to that, even if you mention, the representation in parliament, all of those are not issues.
That's why
because you have given the discretion to the president. Then don't limit him.
Mr. Speaker.
Let me state one point. Honorable members, let me state this point. Let me state this point for all to understand. The office of the president should be a very powerful office in the republic. Should be a very powerful office. Let's not make this law, because we have this perception that somebody else is in power. Make this law, put in yourself. It might be you tomorrow. APC is certainly going to come to power. Another political party is going to get power. Everybody is going to come to power. It is for all of us. NGC will come to power. UNDP will come to power. It is for all of us. Or PDP. potential to win power. As a nation, we should make the president very, very proud. Because it is the president that must take critical decisions. Not with the kind of perception to say, oh, it's because we are not in power, we have to limit the authority of the president. No. We are not making this law for any political party. We are making this law for any president that will belong to any political party. We have flag bearers all over the place. They are flag bearers because they have this belief that they will win elections and become president. They too will not support a thing where you seek to reduce the power of His Excellency the President. I will not sit here as speaker to allow the position of the president to be watered down. It's a very serious process. Somebody has to be in charge of the nation. Somebody has to be in charge. Somebody has to have supreme executive authority. We cannot create a lame duck president. We cannot create a lame duck president where if he needs to do anything, he has to consult Mr. A, consult Mr. B, or he has to take permission from there. No. We cannot create that kind of president. Yes, leader of the opposition.
Yes, Mr. Speaker, I agree with you. I agree with you on this. Mr. Speaker, I agree with you on this because we don't make laws that regulate the president's authority. That is why we are saying, according to what is just read, it means the president will be bound to appoint him according to the strength of parliament. The representation should reflect the parliamentary strength. And we are saying
the use of the word may is discretionary. It's may.
Yes,
not shall.
Yes, let me answer. Mr. Speaker, there are not, for example, the current configuration of this parliament shows that there are only two political parties in parliament. It means if this law was active, it means the president was just going to consider two political parties and leave all the other political parties. So we are saying if there is regional awareness in that very law, let us stop it at that. Let us don't believe parliament because we'll be limiting the powers of the president to appoint.
The mention of parliament, if I understand what you were trying to say, the mention of parliament is just one of the options.
So
just one of the options, not the entire option.
No, if you read what he says, it emanates the option among the other options.
Read that one again.
If there was all,
hold on, read that one again.
Mr. Speaker, the proposal reads as in appointing ministers and deputy ministers, now of course we move to section 61. Actually, the president may consider as far as practicable.
Yes.
A, the political diversity of parliament,
that's one option.
But, Mr. Chairman,
that's one option.
The chairman, honorable members, we will define with removing A and then we will not do this to making appointments. Then of course we'll agree that this moves to section 61 to cover all the appointments, basically the constitution of the government. But then to now read as presently considered as practicable the regional and district balance of the republic, gender equity, we will want to keep that in there. And then inclusion of minority groups here should not be appropriate.
Yes,
considerations. Thank you.
So are you okay with that now?
Mr. Chairman.
Yes, Honorable Tamakeli.
Mr. Chairman, I have a question on the utility of introducing such an uncertainty. Mr. Chairman, let me read for you what Section 59 provides. It says,
We are now dealing with 61,
Yes, no,
not 59.
Yeah, but it's from that. Because the same unity.
We have moved away from 59.
Yes.
We are now dealing with 61.
Yes, I understand that. Yes. But Mr. Speaker, the President, under the President Constitution, and the discretion, it may such other ministers. Any president with a modicum of common sense would know that after the election, you want to constitute a cabinet that represents every part of the country without anybody telling you. Because it's political. Depending on that, if the people of Komon vote for the president, he will know that you have to have the minister from Komon. If the people of Kabbalah, do we need to put this in a constitution, clutter an important document like this?
This is a document of national unity. We are trying to create a document of national unity.
And then give political
so that is why that one is very relevant. So that's why it's relevant.
So political competition is really what this is intended to keep. Party competition.
Kelly, where are you taking that argument?
I'm taking it to the point I'm making. Our constitution is based on the ability of individuals to organize themselves in political parties and compete for political power.
So how do you kill political competition by that provision?
By poaching, because this is really what they are saying. Go to the other side and poach.
And you think you don't have members of different political parties in the regions? Don't you have APC people in other regions or SLP people in other regions? So please, Honorable Tamba Kelly, I think you are over sophisticated for this. Yes, we proceed. Yes, are we done with that? I think this one is not contentious. Also, we are done. Also, yes, one more. The rendition. Yes. Mr. Minister, can you do that now?
Speaker, honorable members, noting that this now moves under section 61. Section 61 reads, subject to the provisions of this constitution or of any act of parliament, the president may constitute offices for Sierra Leone, make appointments to any such office, and terminate any such appointments. We will now move what originally read as in appointing ministers and deputy ministers will now read in making appointments under this section. The president may give consideration as far as practicable to A, the regional and district balance of the republic, B, the gender equity in line with section 35, whatever the provision section of justice and equity. Okay, gender equity. So A, regional and district balance of the republic, B, gender equity, C, inclusion of minority groups.
That's so powerful, eh? Very powerful. I hate it, you have made my day. That's so powerful. Yes. This is my best provision. Very okay. Not so immediately. Yes, so we go back to page 14 also.
Yes.
Page 14.
Page 14, Mr. Chairman.
Yes. Yes, Honorable.
I raised an issue before you mature. I just want to know whether it was accepted or not. I only had another thing about saying E and then you adjourn.
Which one?
So it had to do with deleting subsection 8 of section 54. Page 14.
Oh, okay. What is that?
So it was saying delete subsection 8 of 54. That is clause 11.
Clause 11. We delete the entirety of clause 11?
In clause 11, in the two paragraphs, we only deleted the word president because it was dealing with the vice president, so we deleted president because that was
So what do you say? So in this one, it says you repeal and you replace the subsection. And when
don't want us to limit their participation of being ministers of government. I want us to extend to becoming members of parliament as well.
Yes,
Mr. Chairman, thank you for opening our eyes for the sensitive issue of set nature. And the debate, some of us did not mention 76, the debate, to see how members are taking. For some members, we talked about 76. So what you have done as a presiding officer, you have made a plea to all of us. Consider that things have changed, transformation, contributions to Sudan after the interregnum, so many things have changed. So for me, I am positively supporting it with some caveats. The caveats will come, and we accept one or we go to the amendment.
So can we agree on the conditions?
Yeah, we are not coming. If we need us, the minister has some, if we prefer. Yes. But let me make my first three submissions. Anybody that has to do with the presidency, that's why it's a bar. The president, the vice president, and those who are going to see to be acting in the capacity of the president when the president is not around with the vice president, the speaker, the chief justice, and even sometimes by extension the deputy speaker can be involved. So we are going to put a ring around those things.
zoning them. That's the point. Why? These are our brothers. They've gone out there. They can never be more patriotic to this country than any other country. So my submission is, let us limit the restriction and let us keep our minds open. 76-1 has been in our constitution for the longest time, not until the revered lawyer Francis Cameron raised it. But all of those people that have been serving during that period, when 76-1 was in our constitution and they hold dual citizenship, they have never tried to undermine the state. They have never created a situation to undermine the state. So let us be open and let us pass the law so that it will benefit our brothers and our compatriots.
Mr. Chairman, I listened to the Deputy Speaker spoke eloquently and even made points for our brothers and sisters in overseas. I don't want to repeat myself. I don't want to say thanks to the AG for bringing us to speed. We had this same provision in the 5th Parliament. We had so many discussions around it, but we were unable to do the amendment based on certain reasons. Today, we have the opportunity to make the amendments. Definitely, there are going to be caveats, but we want to do it with consensus, maybe with the paramount chiefs and my colleagues on the other side. So we can agree on certain caveats, but a caveat that makes sense to everybody, that is practicable in even overseas. In overseas, you can have dual citizenship, because if you follow the phrase, supporting why proposing for us to do the amendment, they said in clause 14A, Roman 2, the citizen of a country other than Sierra Leone, having become such a citizen voluntarily or in order a declaration of allegiance to such country. We are mindful of that statement, but they are patriotic in Serbia, as you said. Let me not go over that. There are in countries like in America, as long as you have dual citizenship, you cannot be part of the police force. So we cannot say you cannot be part of the police force, but for example, the Inspector General of Police, you are talking about, as you said, for the Attorney General, that is another case, because as the General, the position of it, even in the Constitution, is secret. That's why the AG, when appointed, doesn't come to Parliament for approval. The nature of that office is very critical. So it's a matter of just all of us to give the responsibility to the chairman of the State Committee to put something in caveat that we can agree. And as we talk about ordinary residents, we have taxes, local tax, NACIT, all of these things we can work on, so that it just can serve as what we have in best practice. That one could be a way to appease certain people. I know my colleagues, before this time, all of us, we have been apprehensive about what will happen to our this, to that. But we are doing it in the true sense of the seriousness we have, the loving spirit we have for our country. So the spirit is this, that let us do this amendment, that we accommodate our brothers. During the interregnum, all of us, let's be honest, we are yearning to go overseas. And if overseas, as Honorable Yata said, we are given the opportunity to naturalize, thinking about the time we were, the difficulty during the interregnum, and thinking about the maladministration for over 20-something years before the war. All of these things. So we have to rethink, to reset our memories, to look at where we can go. And it is not a pro bono business. We have accepted. That's why I said, let me say thanks to the minister. And your appeal he made is very clear. So as we just agree to accept the amendment with caveats, let us go to the caveats in the world. Once we look at other clauses, we are coming. By the time we reach here, we now have a discussion around the caveats that we put around the 76-1. So I advise Mr. Speaker that going into over and over, it doesn't make any sense to all of us. Let us agree, we move on, we come to it, having a caveat that we made a consensus caveat. I respect this,
Okay, after Honorable AKK, then I'll listen to you. Can you do something beautiful? Let's work on something beautiful.
Mr. Speaker,
yes.
Honorable members, I supported this bill and it's part of the clause and I will always do at every level. My first, I start with an appeal. Since this voting will be done on a secret ballot, I appeal to my great MPs that for the sake of the progress of our nation, this particular one that has to do with 2C, let us vote for it and don't vote against it. But Mr. Speaker, my worry is when we put all the caveats, there is one we've not mentioned. What if the person has committed a crime from the country where he's coming from, maybe rape, and is being deported? Do we have a situation in the law, Mr. AG, where we examine the criminal record of the person, where he's coming from, before allowing him to a kind of background check? No, I'm talking about being a member of parliament. You don't go to appointment committee to be a member of parliament. The police clearance is for internally in Sierra Leone. Can you listen to ourselves?
You see, you don't even need to worry yourself about that. The opponent will bring forth all of those.
No, Mr. Speaker. Why do you want that in the law?
Very powerful.
Mr. Speaker, you can read it.
I know what you're saying, Mr.
You can read it up, but if there is no law,
Thank you, Mr. Speaker.
Would there be a caveat to that effect?
Thank you, Mr. Speaker, honorable members. I support caveats, just not to extend them so much. I'd like to provide some context with your name, Mr. Speaker. But to the point raised by the honorable member, we have already proposed language in this bill to disqualify persons.
Chairman, point of order.
Yes, so hold on, Mr.
First, in every provision, sorry, sir. If you want to build a house, you have to get a planning permission. If you want to be involved, you don't give the bricks the appropriate time to build, you have a collapse in the construction. You don't put the appropriate iron rod like I mentioned, you have collapse. So we have laid the condition. Yeah? If you look at page 15 of the proposed bill, everything that my colleague on the other side has proposed is there. So what you have said, I said, let us come to putting up in place in caveats. By consensus, reaching out to the other side, the paramount chief will have a document that will be accepted by all. But if you start to address it in piecemeal, I'm afraid, police on this other side, police on the other side, individual feeling. Let us take a break. We have something around it. We present it to all the groups, and we come here to agree. The consensus we need to have. We protect the interests of our states. As well as proposed. Already it is in the bill. Talking about if you're a criminal, you are busy. We are a nation of goodwill.
I agree.
Thank you.
I agree, leader of government business. You know, the point is that we have all agreed in principle. All what we are looking at are the necessary conditions. And that's all the more reason why I told the minister to address us on some of these issues.
Yeah,
but I think, Mr. Minister, hold on, the leader of your position.
Yes, it's clear. They will all be guided by the same legislation.
Yes.
When we say they must not have criminal records, it will cover everybody, regardless of where you come from. The vetting process.
But the conditions for becoming a member of parliament will apply.
Yes, exactly.
All the relevant conditions will apply.
And just as the Deputy Speaker was saying, we should not be too restrictive over our brothers and sisters.
Yes.
We should not limit them. And one of the reasons for which he said parliament is a critical arm of government. If you have allowed somebody to come to parliament and make restrictions in other offices, that person will come to parliament and change the law, change the restrictions. So it does not make any sense. So to me, I am going to advise that we have our open policy.
And let's not go with the idea that we are electing presidents who do not know what they are doing. presidents know exactly what they do. So let's not underrate our presidents. You think a president is going to take somebody with some issues related to his personality, and that president appoints such a person to a sensitive office? No president is going to do that. So let's not underrate our presidents. Yes, Minister.
Thank you, Mr. Speaker, honorable members, and thank you, Leader of the Opposition. I think you addressed my concerns as well, and Leader of Government to the point raised on criminal record. I will not go into that anymore, but I'll just talk about the caveats, Mr. Speaker, honorable members. I agree with members of Parliament who have said we should not stretch this too much. We should not overstretch it. It will be the proposal of government that the restrictions be kept to the positions we have proposed. We have listed those offices that are in line, that are in line for the presidency. Mr. Speaker, honorable members, let's deal with some realities. This country has been through crisis before. We pride ourselves in being a stable democracy. Doesn't mean that the door is completely closed on what will happen in this country anytime in the future. But when we had crisis before, we brought in a Nigerian as chief of defense staff. When we embarked on a reform process before, we brought in a British national as Inspector General of Police. But the examples go beyond Sierra Leone. Even without crisis, there are times when a country will genuinely want to benefit from the expertise of some person holding another nationality. Examples abound across the globe. Mr. Speaker, honorable members, the current Prime Minister of Canada, who was Governor of the Bank of Canada in 2008, did exceptionally well. The United Kingdom, of all places, hired him as Governor of the Bank of England, a position he held from 2013. We have seen Tijani Thiam, an Ivorian, based on his expertise, what he did with Credit Suisse, hired to head the Kigali International Finance Center in Rwanda. But let's bring this home, Mr. Speaker, honorable members. We make a lot of reference to the former Attorney General Abdullahi Conte, who we sometimes say the architect of the 1991 Constitution, and who sadly passed not too long ago. Noting that in Belize, there was Chief Justice for 10 years. So this is how other countries have benefited from persons who hold our own nationality. So restricting the space to all of these positions that have been proposed, we might be tying ourselves in ways that might affect us in the future if the need arises to look beyond persons carrying just the Sierra Leone passport. So it will be a submission to this honorable House that, yes, this comes with a caveat, but such caveat be limited to the positions that we have proposed, and that they not be extended for reasons that I've mentioned as examples that I have provided, the restriction will be extended. In fact, another example, remember the former commissioner of the Metropolitan Police in London, who was moved to New York, and all of that. So, again, we have Sierra Leoneans providing expertise in different parts of the world, and those Sierra Leoneans, we have not even talked about foreign nationals, but those Sierra Leoneans who were born here, or those persons who are Sierra Leoneans by birth. I don't want my quota, Dr. Mufa to come after me. But those Sierra Leoneans, those persons who are Sierra Leoneans by birth, what happened for any reason whatsoever to hold citizenship of another country, I agree with the chair of the legislative committee that those persons should disclose those other countries that they hold allegiance to, for that for positions to be held, we propose that they be limited to those that are in line with the presidency. That would be my submission, Mr. Speaker.
Yes, page 14.
Mr. Speaker, please, I want to call your attention to the time.
Okay.
It's past 3. And I move as SO5 to suspend it for the business of the House of Representatives.
Any seconder? All those in favor say aye. Those against say nay. The ayes have it. Proceed. Page 14? 15. Yes.
Clause 14B2, which is at the top of page 15, 20 page. Yes, page 15. It begins from page 14.
Yes.
It says,
hold on. At this stage, I recognize the presence of Honorable Leone, who is here with us. Yes, proceed. Page 14 to 15.
yes, at the bottom of page 14. It says, the public officer who is 1 employed or paid from the consolidated revenue for, and I have problem with this woman too. And say at a level that requires him to clear his assets under the Anti-Corruption Act 2008 and shall not be eligible to contest an election under the Constitution unless he resigns from the office at least 6 months before the date of election.
Yeah. Honorable members, how many months?
Yes,
How many months? You just tell us the months.
no, that's not my contention. My contention, my first contention is with the wording.
Yes.
It says in the at a level that requires him to declare his assets under the Anti-Corruption Act 2008. So it means the day Parliament changes the Anti-Corruption Act 2008 or any other law,
Yes.
then it will not be
Yes,
it will not be effective.
Mr. Minister. Mr. Minister, that is the crafty way of putting it.
Mr. Chairman.
Yes,
You don't want to.
Yes, just shortly. I'm going to suggest that we revert back to how it was. Because we just changed from 12 months to 6 months so that we have earlier opportunity.
Yes, these are leader of government.
I think they have said the next one was very clear on that.
Yes, very clear.
See,
so leave it at that.
Yes, I do.
AJ, we leave it at that. Yes.
We are amending that because several times. Yes. We were stating the law that we are carrying by extension. We are giving our assets.
Maintain the law as it is.
Yes.
Mr. Chairman, this parliament should be on record to note that if we are flexible, we have to be flexible right through. If we are flexible with our brothers outside, we have to be flexible within.
There is no way you are going to win that. So please, there is no way you are going to win that.
Mr. Chairman, you will be shocked that I will 46 one and you will see member of vote and will fight.
Honorable members, don't waste my time. There is no way anybody is going to win.
Mr. Chairman,
Hold on, Mr. Chairman.
my brother is serving in the armed forces, and my brother has served up until a period to defend this place for the territorial integrity of this nation. And he wants to be a politician now. He's not carrying the real position. Why do you compare more?
always say why?
Mr. Speaker, maintain the law as it is.
Mr. Speaker.
Yes.
Just some good comments on this. I mean, I think the reference to
somebody is saying it's because you have no more interest in
No, sir. You see, what I believe in my words, and I believe in the way I define people. So this time, the intent of time is zero. I have said it. And I am contesting, and people know I am contesting. Whether any of that, I will still come back. Even my chairman is a
Mr. Speaker, honorable members, context matters. I take the comments made by the leader of the opposition about reference to the Anti-Corruption Act. We will include that as amended.
Just
but the rationale, Mr. Speaker, this Parliament amended the Anti-Corruption Act to require persons employed in the civil and public service below a particular group to not have that obligation to disclose their assets. That also informed our thought process. But I'd like to give examples, Mr. Speaker, under the members. Not so much for the soldier. Of course, I take that example as well for someone who has served. But I always like to give this example of a teacher or a health worker in Bikolo, or in Mongo, or in Thailand, someone who has served their community, and they carry the trust of that community. But of course, we know the conditions under which teachers in certain communities or in the country serve in this country, or health workers. But then, they are so respected, such persons are so respected in their communities, that these communities want to send them to Parliament to represent them. So what we are saying, Mr. Speaker, honorable members, with this provision, we basically say even someone at that level, a primary school teacher, who carries the trust of their community, and who that community wants to send to Parliament to represent them, we say that person at that level must resign and live in poverty for 12 months before they can come to Parliament. That would be, in my humble submission, absurd. I don't think that would have been the intent of the framework of this constitution. And so it is an submission that such persons that work in the public and civil service below a particular grade be exempted from this law. Thank you very much.
Yes, hold on. Okay, after leader, I will allow the leader of the opposition behind the chief whip. Yes, leader.
If we are flexible enough to encourage our brothers and sisters who are still in diaspora to come and participate in the process, we should also be flexible enough for persons who are going to be part of it, who have contributed, they have worked, and we have persons who retire, let's say 6 months, 8 months to elections, who have served the civil service, the public service, 8 months to elections, and we have said that person should not be given the opportunity to Mr. Speaker, hold on, sir. Let me just start. Mr. Chaba, let me land, please.
Yes. Hold on. Give me 1 minute. You know what? All those who want the law to maintain the law as it is, stand up. No, hold on. All those who want the law maintained, the law that has to do with 12 months, Just stand in your place, let me see. Those who want the law to continue as it is, they resign 12 months before election. Stand up, let me see. Let me see.
Mr. Chairman, I advise that the president will give a caucus to this way.
Okay, sit down, sit down. All those who want 6 months, stand up. 6 months.
Mr. Chairman, Mr. Compton, I'm not going to go to 6 months. I will have to see this man up. Because I know some people who have chosen their place to go to the children.
We are free to vote.
Yes, so you know, SO 46.2 takes provision for abstention. So a good number of them are still.
No, I am sure if you have a secret ballot, we will know whether or not they want to support me or they want to support us. Because we are together.
Chairman, they are poor.
Honorable member, leaders.
I was expecting to support me.
I don't need a test case. I don't need a test case for you to know that your argument is in futility. I don't need a test case for you to know that your argument is in futility. So instead of wasting time on this particular matter, let's get more.
No, let's take a beat.
Okay, I'll take a beat.
Let's take a beat because we don't have full house. Mr. Chairman, we don't have full house. Let's take a beat. Mr. Chairman, let's take a beat on this because we don't have full house.
Yes, proceed.
Yes, to me, I think it is very unfair. So we limited from contesting for members of parliament. So I want us to cascade it a little further. There are public officials who are also contesting for flag bearership in their political party that are using public resources to campaign, to go to prison. So also, if anybody wants to contest for flag bearer in his political party, what's the sign? For those who want to
Mr. Chairman, the 1991 Constitution is clear over the use of state resources for political gain. That is why the 1-year ban was made for civil servants and people working for government. And these are people who are under instruction. They are not necessarily earning the institutions and the resources. They don't have total control over resources. But what the leader is saying, we are talking about commissioners, we are talking about ministers, people who carry total responsibility, and they move place to place using their authorities to gain their own individual and desire for president. Mr. Speaker, if we are divine teachers who are paid 2,000 euros, if we are divine ordinary a civil servant who are paid 1,500,000, who do not have, they don't use fuel, they don't have government vehicles, they don't stay in government quarters, I think it is more fitting for the safeguard of state resources we expose it to the president.
Yes, Mr. Chairman, I feel we are about to set the very bad piece here. Mr. Chairman, when we are doing constitution and we are unfolding, the vote is single majority. And I believe when you pose the question for the 1 year and 6 months, there was a vote. So if you come back to that one, you stick a pin to it.
No, we are not sticking a pin, we are done with that.
Thank you. So which stands? Mr. Chairman, no, there was no winning. No, there was no winning on the vote. Mr. Chairman, in fact, the argument of protecting the use of state resources really supports the higher position that persons working below a particular grade, who in fact will not have access to state resources beyond their salaries, be excluded from this. Mr. Minister, the judge has ruled, the president has ruled.
Mr. Minister, maintain the law as it is. Honorable members, at this stage, I recognize the presence of the chairman of the LCDP. I also recognize the presence of the chairman of APC, Ambassador Usman Lebes. I recognize the presence of the Deputy Minister of Mines, who was the Secretary General of the LCDP. I also recognize the presence of the Secretary General of APC, Mr. Lanza. I I recognize the presence of the principal executive advisor to His Excellency the President of Public Service, Dr. Emmanuel Gain. I also recognize the presence of the Deputy Mayor of Freetown, Mr. Kukulis. I recognize the presence of a very powerful female former member of parliament who also doubles as the current advisor of His Excellency the President on parliamentary matters, Honorable Dr. Fatmata Hassan. I also recognize the presence of one of the key negotiators of the Agreement of National Unity and a very powerful member of the APC, Dr. Kefala Mara. I recognize the presence of Madam Haja Fatmata Kamara. Are you here? She is the Deputy National Women's Leader and Deputy Minister of Trade and Investment. I recognize the presence of Mr. Nabil Musa Kamara. Is he here? I recognize the presence of the press attaché to the High Commission, the Israeli High Commission to the Gambia, Madam Awa. I recognize the presence of Dr. Victor A.B. Davis. I also recognize the presence of Alhaji A.K. Sese. I recognize the presence of Mr. Harold Toure. I also recognize the presence of Mr. Ibrahim Solisisi. Mr. Ibrahim Solisisi is the Secretary General of ABBA. I recognize the presence of Mr. Simeon Bangura. I also recognize the presence of a very senior lawyer in this country, Mr. Adi Macaulay. I recognize the presence of the Chief Executive Officer of the Small and Medium Enterprises Development Authority, Mr. Shaka Samusano. I recognize the presence of a very strategic member of the APC who also doubles as a former minister in the APC government-led government, Mr. Balogun Kuruma. I also recognize the presence of Madam Mariam Malu Pangura. I recognize the presence of the former mayor of Freetown, Mr. Herbert John Williams. Mr. Speaker. Yes, Mr. Speaker. Yes. Please. We have Madam Mariam from Bangura, Mariam as the women's leader, national, the APC. Yes. Unfortunately, Tunde, that is not written down. We recognize you. I also recognize the presence of Mr. John Sese. Mr. John Sese is here. I recognize the presence of Mr. Mohammed Pope Kamara. I recognize the presence again of Honorable Ayamara. I recognize the presence of Honorable Lahadi Aladi. I recognize the presence of Honorable Alusan Alukote. I recognize the presence of Honorable Johnson. I recognize the presence of Mr. Daniel Mongo Kamara. Where is he going? And I recognize the presence. Okay, we'll come to that later. We'll come to that later. Proceed. Yes, Mr. Minister.
Mr. Speaker, there was a proposal put forward by my leader that the minister had to respond to. And I second that, I echo my voice to it. Our argument basically is saying, because we want to minimize the use of state resources and create a level playing ground for ministers.
Yes.
We are saying, Mr. Speaker, if a teacher wants to be a member of parliament, he must resign 1 year.
Hold on. Let me recognize the presence of somebody who have been coming to this world that you do not know. Let me recognize him today for all of you to know. And he's been a lecturer in the law school for over 30 years. He's the lecturer of Honorable Givao, the lecturer of the AG, the lecturer of the Speaker, the lecturer of Honorable Dade Kumar, the lecturer of Honorable Tibo, the lecturer of Tambakeli, Honorable Tambakeli. He's the lecturer of all of us. And he's Mr. Daddy Sitop. So if all of us make presentations on the line, it was one of those that made all of us, all the lawyers there, without exception, all the lawyers there, all the lawyers. You had me yesterday morning, Honorable Thibault, when I told him your lecturer was the one who did the drafting and was there arguing. That's the lecturer who lectured all the lawyers you have seen here. The AG, the Speaker, Honorable Gilbert, everybody here. So I particularly recognize his presence. And you are heartily welcome, sir. Of course, sir.
In addition to that, going for a very popular statement at the law school.
Yes.
Before whites, the whites.
So I also recognize the presence of a brother, Mr. Patrick Robin. I saw him at the back. Please stand up to recognize his brother that he came here today. Is that the Abadi flag? Is that the Abadi flag? Oh, yes. Thank you very much. Yes, Mr. Minister.
Yes. I am of the firmest conviction that it is not fair for public officials to be subjected to the circumstances that ministers of government are not subjected to, especially when the AG said that for great Noah I agree with him because teachers have paid very small salaries, so they cannot suffer that. But government ministers receive one of the highest salaries. So if a public officer should resign 12 months before contesting for a member of parliament position, a minister should resign 12 months before contesting for a president.
Honorable members, please listen to me. Let me address this point. Honorable members, to say that somebody is contesting for a particular position is a question of fact. It's a question of fact. You won't be able to prove that somebody is contesting for a particular position. There is no way any one of you can prove that a minister is contesting for a particular position. In fact, most of the time when ministers are ministers, they don't come out openly to campaign. They don't come out. You only see somebody posting their pictures and somebody posting that they are contesting. It's a question of fact.
Mr. Speaker, it's in support of the statement that you're making.
Yes.
Because I am not sure that there is any minister that is contesting. It shows that I am not malicious in suggesting this one. So if there is any minister who is being hypocritical, if there is any minister who is hiding his intention, then the law will hold him for
Mr. Chairman, honorable members, for you to participate in your standard politics doesn't guarantee you the automatic ground that you are a candidate. Our point here is you should not be a flag bearer. For you to participate for the position of flag bearer doesn't guarantee you that you are a flag bearer. It's an internal party dynamic. And the party, honorable members, the party, our political parties should be able to censor their candidate in making sure that the candidate fulfill all the criteria that he should fulfill based on the constitution. So if the parties present candidates that are not fit for purpose, then you have an opportunity to protest. Because for you to say you want to participate and you should decide and you apply towards the position, then that's
Sit down. Mr. AG, proceed. Let me hear you. Proceed. We have got 15.
Mr. Chairman, on page 15.
Yes.
Mr. Chairman, 15.2.
Yes.
That for you to be qualified, you should not have been found guilty of certain offences.
Yes.
But at the same time, pegged it that even when you are found guilty, if an appeal is pending, because there is an appeal, it does not serve as a disqualification. Mr. Chairman, I think.
Is that what you said?
Yes. When you come to, it says, a person shall not be qualified for election as a member of parliament if he has been convicted of any of the following offences and sentenced to imprisonment for a term not exceeding 12 months without the option of a fine, whether the conviction occurs in Sierra Leone or elsewhere, if the conduct would constitute an offence in Sierra Leone. And when it comes further, it says any other offence punishable by imprisonment for a term exceeding 12 or more, provided that a person shall not be regarded as disqualified until an appeal against the conviction or sentence has been determined or until the time for an appeal has expired. My point is, it means you remain convicted, even though convicted, but because you have an appeal, you are qualified to contest.
A convict is a convict.
A convict is a convict.
A convict is a convict.
So I am saying we remove that clause of
until the appeal is determined.
Yes.
So we just leave it at that.
Yes.
Until the appeal is determined.
or until you succeed at an appeal, you are still a convict.
Yes, Mr. Speaker. So we have to look at it to reflect that position that you have held. Not merely because an appeal is lodged, will you be qualified. Even if an appeal is lodged, until it is determined you remain a convict. But that's not what it is.
Appeal is determined you are a convict. So no, we have to. Yes, leader.
Mr. Chairman, you are making a point that is already agreed by the proposal in front of us. And I don't know why you, if you read it, F, you are reading F. Any other offense punishable by imprisonment for a term exceeding 12 or more, provided that a person shall not be regarded as disqualified until an appeal against the convicted or sentence has been determined, or until the time for an appeal has expired. Mr. Chairman, I think principle of natural justice applies here. Normal situations where you think you have the right to appeal, even when you are convicted in the cases, said because the principle of natural justice giving you the right to make another case or a submission. Our laws speaks to the fact that you have to make an appeal. So if you are giving an appeal, the only thing that can be different from here is the issue of integrity issues. For elections, I really have to do a lot of integrity because you want to man the office of state. So why now we can agree to make it very clear instead of subjecting it to the normal circumstances where you appeal. For election purposes, we can say even if you are having an appeal, until the appeal is cleared or the court is giving a judgment against the appeal. But for me,
if the appeal is determined in your favor, you are a convict. And it will be outrageous for us to make a law to say that as long as you have an appeal, you cannot allow convicts.
No, yeah, wait. So now that's what I'm saying. No, this clause now on the next sentence is say you are not disqualified. So that's what I'm asking. Yes, look at it. Let me read. No, provided that he said any other offense punishable by imprisonment or by a term exceeding 12 or more. The next one, provided that a person shall not be regarded as disqualified until an appeal against the convict or sentence has been determined, or until the time of an appeal has expired. So the principle of natural justice applies here. That's what they are saying. So I'm saying now for elections, we can agree to say, no, this one, we are waiting for the final hearing of the appeal. So just like you have election courts, if you go to the Public Elections Act, the election court is different from the other courts. They are trying to expedite the process so that we cannot interfere with the rulings. So for me, I think we have to look at it in terms of integrity issues to our elections or the individual, because you are going into an office if elected. But if you are talking about appeal, if you have this issue of criminal conviction upon you, you have been convicted or you have made an appeal, it's a mixed feeling of our constituents. So we want to draw a clear line of sanity that no, this is not about principle of natural justice. It's about principle of decency in our electoral system. I am just thinking about it. But for me, sir, to place some of these things in the Constitution, I don't think it's the right place. These things should come in the Public Elections Act. Let's draw attention to the consequential amendment. Mr. Minister, it should not be in the Constitution. It should be in the Public Elections Act 2022.
Mr. Minister, it's so outrageous.
Yes.
So if you begin to think about this,
yes.
In our Constitution, yes. I don't see any rationale for this. If somebody is convicted, just imagine somebody is convicted of treason, of murder, or manslaughter, of rape, sexual penetration. And you want to even tolerate that kind of conversation?
Mr. Chairman,
you even want to tolerate that kind of conversation?
The reason why I drew my attention to this, in the Legal Practitioners Act, we have a similar clause wherein if you are disbarred, the moment you lodge an appeal, that decision is a stay. The moment you lodge an appeal, so it's the same effect that this clause was about to have. Even when you are convicted, once you appeal, you stand not to be disqualified until that's the effect that this has. So we have to deal with it. Yes.
So, Mr. Chairman, the new legal, the proposed legal practitioners act actually addresses that.
Not the proposed law. I am talking about the instant law, not the.
No, I'm saying we are dealing with it, but this should not really be. It should not be an appeal. It should not be. It should not.
And the sad thing is that when you win your elections, and we start protecting you, we start protecting you, we start invoking privileges. We say, no, you cannot be taken to prison.
So, Mr. Chairman, let's remove it from the constitution.
Totally. When you win, it becomes complicated.
Mr. Chairman, I perfectly want to agree, and as I said, Honorable Gabor made a point on the principle of natural justice. And my colleague now supported my position. But let me tell you, on the issue of the Sexual Offences Act, which I presented to this House, the Sexual Offences Act, there is an administrative aspect of that act, which has not been fulfilled. This issue of sexual penetration, we agree with the moral guarantors that we should pass this act on the pretext that we are going to have an administrative practice to deal with this law decisively that has to do with sexual penetration, the forensic testing. I went as far as the British Council to meet with the High Commissioner. I made an appeal that we have done our best to pass this law. It was a real confrontation between us and the paramount chiefs. And we made certain undertakings that has to do with that particular act. Let me tell you, we need to review that act, in fact. So bringing sexual penetration here is a whole ball game. So for me, we want to make our elections credible and bring some decency. But constitutions are different from other acts. That the way you deal with constitutional amendment is different to the way you deal with the act of parliament. So let us agree, don't take it. Since we are anticipating part 2 of the consequential amendments to this bill, let us just take it to the public elections after 2022.
Yes, that's my suggestion. Mr. Minister, I think that would be great.
Mr. Speaker, yes. Also on the same subject as Leone just said,
yes,
we should try to think about these two elections related offenses. Elections.
Where is the yes?
No, but that was the original position.
Yes.
If you are found guilty of a crime relating to the election of member.
So we could amend the law.
So if we are taking that off, it will also affect the extant law.
Yes.
And equally, I see they are proposing to delete paragraph 8 of the extant law. I don't know why.
Yes, sorry.
Yeah, just hold on. You see, I don't know if we are doing this in tandem with the Public Elections Act. From section 143 right down to section 153 deals with elections, offences, and petition courts. These are serious matters. This act was deliberated for over 3-4 months. If we have just proposed again, talking about offences here, we are ignoring the extant law for elections. We are not really playing fairness to the law. Yeah. So what I've said is just in line with what the Leone opposition said. We are over-legislating, and that is why we overlap with the law, and automatically we are altering the law. That is why Honorable Tawab said, he has just said it. We are altering the law. It's very bad, and in the constitution it is treasonable. Because it's an act of parliament, we are just over-legislating it. We can't do that.
Mr. Minister. Yes, hold on, let me hear from the minister. Yes?
May I confer, please?
You want to confer? Okay, why is this conferring? Yes, let me hear you.
Yes, and Mr. Speaker, when I looked at C, under the offenses that can prevent someone from protesting rape or sexual penetration, I have no problem with rape. But when I looked at the definition of sexual penetration under interpretation, then certain things are missing. I read the definition.
Under sexual
offences act.
Which interpretation? In this bill?
No, part 1 of sexual offences act.
Yes, define that.
Yes.
Read that out.
Yes. It says sexual penetration means any act which causes the penetration to any extent of the vagina, anus, or mouth of a person by the penis or any other part of the body of another person of an object. There's something missing. Without the consent of that other person is not there. Without the consent of that other person is not in the definition.
In the definition.
Yes, it's not there. So when you use it this way here, sexual penetration, it's only because an offense if there's no consent. The definition.
Yes,
Hold on.
There is a reason. Under the laws of Sierra Leone, you do not have a consent until you are 18 years old. Sexual penetration is for anybody less than 18. So in fact, sexual penetration and the same, the only difference is the age. So you do not have right to consent
That is strict liability. That is strict liability. You do not need any consent. Because when you do that to somebody below the relevant age, the question of consent does not arise. There is no question of consent. Yes, everybody.
Mr. Speaker, thank you very much for the education. The truth is, in penetration, it's a child and a minor does not have consent. And because it's a minor, the definition will not include the consent. If the child is 17 years, 11 months, the child is a minor. Even if she's the one who went into your room on the SU, she has no consent. So stay away from kids, allow the kids to go to school.
Mr. Speaker, why are we all referring to minors? Even an adult that's above 18.
Adult is sexual
I'm concerned because he said rape or sexual penetration. Rape or sexual penetration.
Rape for big people, sexual penetration for children.
Mr. Chairman, the penetration here is not the physical penetration of your penis into the body of a woman. It is the act done on a child. Is called penetration. While rape is the act you do forcefully on a woman. So that's why the law is saying for rape, that is an adult. Here you talk about consent. If you look at the definition, in penetration there is nothing like consent because it's a minor. A minor does not have consent. Just as we ask you not to marry the kids below 18 years.
That's honorable.
In relation to my brother's submission, he said an adult cannot be penetrated. Let's say you use your hand to penetrate an adult.
It's called
Mr. Chairman, point of order 34. Mr. Chairman, point of order 34. Mr. Chairman, point of order 34. You see, I just introduced the phrase, and you have now seen the way rancorous we are. So, thinking about putting this in the constitution, because the whole election system to go back. So, what you are saying, you are not making these laws for elections to vilify anybody. we are doing it to safeguard our electoral process to be more credible. So bringing some of these things to the constitutional amendment, it's making us worrisome. Now, how can you legislate defining penetration, non-penetration, when we have it already enacted by this very parliament? How can we see that was deliberated, voted on, and passed by this house? Mr. Chairman, we should not put the law to make it a question. If we seek for an amendment, let us bring it to the floor. Yes, exactly. The chairman rule against who we should proceed.
Are you inducing the chairman to rule against
Mr. Yes, Honorable Sama.
I wanted to suggest in relation to the leader's submission that we amend the Public Elections Act and expunge this from the proposal.
Noted. Honorable Sama. Yes, Honorable Sama, proceed. Are you okay now? Yes. Yes.
Yes, thank you very much. I have a personal concern with regards 3B, which talks about pardon. You know, 3 is actually talking about how